despite identifying 10 plaintiffs in the caption of the complaint, and in the allegations identifying the parties, only one plaintiff attempted to verify the complaint, and that is Atnight Media, LLC, Atnight, through its managing partner, Hong Xia. This purported verification is undated, and there is no indication in the verification or elsewhere in the complaint that Mr. Xia, on behalf of Atnight, had personal knowledge and or information with respect to any/all of the other plaintiffs who purport to bring claims against the defendants through the complaint, to be able to verify the complaint on behalf of the other 9 plaintiffs, nor is there a statement as to why there is no verification provided by any of the plaintiffs other than Atnight. Curiously, Atnight does not even assert any purported claim against the defendants in this case. Moreover, it is clear from plaintiffs' subsequent filings, including the responses to the anti-Slapp motions, not only that the other 9 plaintiffs were able to provide verifications, but also that they were aware of their obligation to submit individual verifications. In addition, plaintiffs filed 2 responses, each with the same timestamp to the barbecue motion, both of which contain not only verifications from the plaintiffs in this action, but also from a MC and KC, 2 individuals who, like dozens of other non-party individuals and or entities mentioned in the complaint, are alleged to have played some role in some aspect of this case. It is not clear why verifications from the Cs were attached and or how the Cs could verify that the representations in plaintiff's response to the barbecue motion were accurate and truthful. In addition, plaintiffs' untimely responses to the anti-Slapp motions, unlike their complaint and injunction petition, both of which included the name of attorney Lesniak and another attorney Brussel, Castor, Jr., ESQ above the caption, not only included verifications from each of the plaintiffs, but also were submitted with only attorney Lesniak's law firm on the submission. F. Finally, the court notes that all of the responses improperly attempt to change the caption in this case to add, without agreement of the parties or court order, comma, a new defendant, Stephen J. Fisher, and to change the number of Doe defendants from 4 to 50 to 1 to 14. The court notes that the same plaintiffs filed, also on October 18, 2024, a petition for preliminary injunction and final injunction and other equitable relief, which was filed without any verification from any of the plaintiffs. The injunction petition, like the complaint, also lacks any exhibits in addition. No certificate of service was appended to the injunction petition. As such, the injunction petition was not referred to the undersigned or any judge of this court. This court notes that while Atnight and Dwayne Dog Chapman are named plaintiffs, neither of them asserts any count or claim that avers any specific allegations by these plaintiffs against the defendants. The purported causes of action appear to include, but are not limited to, causes of action for defamation, harassment, intentional infliction of emotional distress, cyberstalking of a child, and cyber harassment, civil conspiracy and coordinate defamation, criminal conspiracy, interference with prospective business relations, violations of the Pennsylvania Corrupt Organizations Act, violations of the Racketeer Influenced and Corrupt Organizations RICO Act, and violations of other criminal statutes. Abundant paragraphs in the complaint describe how plaintiffs themselves have intentionally taken their investigation for the missing child public by, for example, publicizing the dispute through plaintiff Dwayne Dog Chapman's many live television appearances, publicly issuing a reward for information, and accusing the missing child's stepfather of being involved in the disappearance. The complaint fails to allege a cognizable RICO action under Section 1962(c), and the responses to the anti-Slapp motions fail to address the arguments on this issue, as raised by defendants' anti-Slapp motions. Again, and notably, while the court permitted supplemental memoranda from all parties following oral argument as to the anti-Slapp motions, plaintiffs failed to provide any supplemental brief in response to the defendant's arguments at oral argument, including but not limited to the failure of the complaint to state a cognizable RICO claim, which brief could have addressed these specific issues raised by defendants. Finally, the counts of the complaint do not establish that defendants engaged in any pattern of racketeering activity, nor does it establish a RICO claim under Section 1962d of the statute. Plaintiffs' responses therefore purport to address only four of the 47 counts described in the complaint. Neither untimely responses nor in plaintiffs' presentation to the court at oral argument did plaintiffs ever address any of the other purported 43 counts to which they allude in the complaint. At oral argument, plaintiffs not only requested that the court expand the record by considering vast amounts of purported evidence, including but not limited to hundreds of hours of podcasts and other written documents, that they chose not to submit in any form 4 months prior, but also requested a continuance of the oral argument so that they could undertake discovery. Defendants objected vehemently to the request, suggesting that discovery is more nonsense added to an already egregious scenario that's before this court, allegation included people identified as plaintiffs to try to intimidate, including but not limited to a complaint that lacks a single properly pled with no allegation about any claims whatsoever, and allegations that are two women who had to put up with this stuff. As such, the court requested again that plaintiffs identify the discovery they need, to which plaintiffs responded as follows as to the basis of their podcast. So we have podcasts going all the way back to some information beginning of October from these two defendants regarding my clients and statement made about my clients. Simply put, there was no good cause to grant the request. Indeed, granting the request would have contravened the spirit and express purpose of the Pennsylvania anti-Slapp statute. The complaint is signed by Joseph P. Lesniak, ESQ, who is the attorney of record in this case, and is also identified in the case caption. While the court notes that Mr. Lesniak practices primarily in the criminal courts, he has, according to his website, some experience in non-criminal matters as well, and certainly understands or should understand the rules of a pleading governing civil complaints. Although the caption of the case also identifies attorney Bruce L. Castor, Jr., ESQ prominent attorney, with a significant local, statewide, and national reputation, Mr. Castor did not sign the complaint and is not counsel of record, as evidenced by the lack of any entry of appearance filed by Mr. Castor for any of the plaintiffs in this case. Nevertheless, the complaint describes attorney Castor as being intimately involved in this action on behalf of plaintiffs. Plaintiff Dog the Bounty Hunter, accompanied by co-counsel the Honorable Bruce Castor, Esquire, appeared live on Court TV during the morning show discussed the disappearance of Sebastian Rogers. The complaint then sets forth in great detail what attorney Castor purportedly said, emphasizing his alleged words that if things worsen, will recommend plaintiffs take legal action because this situation has become totally unreasonable. At oral argument, Mr. Lesniak represented that attorney Castor was not, in fact, an attorney of record, but was consulted in this matter and gave permission to use his name at the top. Exhibits attached to defendants' submissions in connection with the anti-Slapp motions reflect not only that attorney Castor is not involved in this case, and any indication otherwise is in error, but also that attorney Castor requested that plaintiffs correct any misunderstanding in that regard so that the court, counsel, and litigants are aware of attorney Castor's non-involvement, as attorney Castor would rather not do anything official to draw attention to this issue. In addition, the complaint includes numerous allegations in the first person, about attorney Lesniak's interactions with the parties to this action. This pleading style is not only highly unusual in a civil action, but also of some concern. as counsel appears to be a fact witness in the case. Mr. Lesniak himself, at oral argument, noted that he had gone on defendant's podcast and had witness statements and even interacted with defendants about their statements.